the hearing of the subcommittee on the workforce protections will come to order. I will open the hearing with my own remarks and then yield to my ranking member, who is on her way, but she probably doesn't care if she doesn't hear my opening remarks. She'll read them in the record. So, welcome everybody. Today is Workers' Memorial Day, a day when Americans from all walks of life remember and honor workers who have been killed or seriously injured in the workplace. We have in our audience today many family members and loved ones of workers who have been killed in the workplace. I thank you for coming. This is an honor to us, but the very idea that you would take your time and come here knowing how important PAWA is, but also how emotional this must be for you. So thank you very much for being here. Memorial Day started on April 28th, 1989, a day which is also the anniversary of the Occupational and Health Act, OSH. This is the 40th anniversary. Well, it's the 40th year, it's the 39th anniversary. Unfortunately, over 20 years later, it's the 21st century, and workers continue to die on the job. This past month has been a particularly tragic one for American workers. Last week, on April 20th, 11 workers were lost and 17 injured following an explosion on the Transocean Deepwater Horizon drilling ship leased by British Petroleum BP in the Gulf of Mexico, 50 miles off the coast of Louisiana. On April 5th, 29 miners were killed and 2 injured in a massive explosion which whipped through Massey's Energy's Upper Big Branch mine in Montcole, West Virginia. 3 days earlier, on April 2nd, a blast at the Tesoro oil refinery in Anacortes, Washington, caused the deaths of 7 workers who were engulfed in a firewall. There are thousands of equally tragic deaths that occur in ones and twos away from the limelight. Last Friday, another West Virginia miner was killed at ICG Beckley Pocahontas mine after he was crushed between a continuous miner and a rib wall. Last month, the subcommittee held a hearing on the civil and criminal penalties of H.R. 2067, the Protecting America Workers Act, which we call PAWA, and I'll refer to it as that for the rest of the day. It's shorter. These changes are long overdue, and they are changes to and reforms to the OSHA Act. Today's legislative hearing will examine the victims' rights and whistleblowers provisions as they are contained in the March 9th discussion draft of the same bill that further improves PAWA. When workers are killed on the job, family members need to be included in the investigations, as they may be a rich source of knowledge. Victims want investigations to get to the whole truth and to ensure that the death of their loved one was not in vain. And they want meaningful changes so that other workers do not meet the same fate. One of our witnesses today is Tanya Ford. Hi, Tanya. Her uncle fell 90 feet to his death from a continuous belt-operated man lift at an Archer Daniel Midland plant in Nebraska. The company replaced this one man lift as part of its agreement with OSHA, but not the others located throughout the plant and other plants that they own. Tanya's father, who still works at the plant, rides up and down on this inherently dangerous equipment on a daily basis. Unfortunately, families have been marginalized by the Occupational and Safety and Health Administration during investigations. Families oftentimes get investigation results, and when they do, it too often arrives after OSHA has met privately with the employers and reached a closed-door settlement. Some employers will insist the deceased worker is responsible for the tragedy in closed-door meetings with OSHA. Yet OSHA informally settles these cases without the benefit of input from families, those nearest to the victim, those who could have inside information shared with them by their loved ones. OSHA's current policy assumes communication with the next of kin. This policy, however, is not consistently implemented and certainly does not meet the needs of families. The discussion draft of PAWA strengthens existing policy by bringing family members into the process. The OSHA Act recognizes that providing healthy and safe workplaces depends on the willingness of workers to raise concerns with their employers or to blow the whistle by reporting unsafe practices to government agencies if or when the concern is not addressed. Too often, however, workers are fired, demoted, or punished for raising concerns with OSHA, and OSHA fails to protect them enough by recovering their back pay or getting them their jobs back. One of the main reasons for this is that Section 11C in the OSHA Act, as the oldest whistleblower statute, lacks due process and other essential protections, and really is stuck back in the 19th century, as a matter of fact. As a result, few cases that are filed are found to have merit, but when they are considered merit cases and OSHA cannot settle the case between the parties, its only option, OSHA's only option, is to refer it to a solicitor of labor. The solicitor then has the sole discretion whether or not to pursue the case in court. Between October 1st, 1995 and October 1st, 2009, fewer than 7% of the merit cases sent to the solicitor were ever litigated, because it appears that first, the solicitor's office only takes those cases that have a very high chance of winning, and second, demands on that office far exceed its scarce resources. And further, agency policies tend to discourage litigation where the amount to be recovered for the worker or the worker's family is small compared to the resources needed to litigate the claim. One of our witnesses, Neil Jorgensen from Preston, Idaho, will testify how he lost his job after filing a safety complaint with OSHA. He filed a whistleblower claim, and while OSHA found his case had merit, the solicitor declined to prosecute because it did not think either of the two federal judges in Idaho, who would be the ones to hear the case, would be receptive to it. Under current law, Mr. Jorgensen had no right to file a case in court. PAWA modernizes the OSHA Act to bring it in line with modern whistleblower laws, such as the Consumer Product Safety Improvement Act. Excuse me. A safe workplace depends on workers reporting unsafe conditions to their employers or the government without fear of retaliation, and with the knowledge that the government will be there to back them up if the employer does retaliate. The legislation before us today will achieve that goal. I'm pleased the administration supports the victims' rights and whistleblower provisions, and look forward to the testimony from our wonderful panel of witnesses. With this, I would defer to our ranking member, Kathy McMorris-Rogers, who isn't here yet. She will give her opening statement after we've heard from all of our witnesses and before the questioning begins. Without objection, all members will have 14 days to submit additional materials for the hearing record. Now I'd like to introduce our panel of witnesses. They're a very distinguished panel, and we are very pleased to have you here this morning. We will start at my left, and that will be the order of the testimony, and I will introduce you all, and then we'll go from one to the other as we progress through the hearing. First, we have Mr. Jordan Barab, who is the Deputy Assistant Secretary of the Occupational Safety and Health Administration. He formerly served as a Senior Labor Policy Advisor on this committee, so we're really out front with you that we love Jordan very, very much, and we respect his words. He also worked as a health and safety specialist at the U.S. Chemical Safety Board and served as a special assistant to the OSHA administrator. Prior to his government service, Jordan was the Director of Health and Safety at the American Federation of State, County, and Municipal Employees, called AFSCME. He holds a master's degree from the Johns Hopkins University and an undergraduate degree from Claremont McKenna College. Thank you for being here, Jordan. Ms. Tanya Ford is a resident of Lincoln, Nebraska, and the niece of Robert Fitch, who died, as I told you earlier, in a preventable accident at the Archer Daniel Midland plant in Lincoln. As a family member of a worker killed on the job, she has worked to raise awareness of the need for better workplace safety. Mr. Dennis Morikawa is a partner in the Morgan, Lewis, and Bacchius law firm, where he heads the occupational safety and health practice. He represents management regarding labor and employment law issues, focusing on matters arising under the Occupational Safe and Healthy Act and the Mine Safety and Health Act. Mr. Morikawa received his JD from the Syracuse University and a BA from Denison University. Dr. Celeste Monforton is an assistant research professor in the Department of Environmental and Occupational Health at the George Washington University's School of Public Health and Health Services. She worked as a policy analyst at OSHA from 1991 to 95 and at MSHA from 96 to 2001 as special assistant to the assistant secretary. Dr. Monforton earned a bachelor's degree from the University of Michigan and earned a master's degree and a doctorate of public health from George Washington University. Mr. Neil Jorgensen. Neil is a whistleblower who lives in Preston, Idaho. He filed a complaint with OSHA under Section 11C of the Occupational Safety and Health Act in 2004 after being fired from his job at Plastic Industries, and he has a real story to tell us. Mr. Lloyd Chin. Mr. Chin is a partner at the Labor and Employment Law Department at Proskauer Rose Law Firm. He litigates employment disputes before federal and state courts, arbitration tribunals, and before administrative agencies. Mr. Chin received his JD from New York University and a BS from Georgetown University. Ms. Lynn Reinhardt. Lynn is the Associate General Counsel at the AFL-CIO, has been since 1996, and her focus is on safety and health law policy. She's a former staffer to Senator Howard Metzenbaum on the Senate Labor Committee and is a member of the Obama transition team for the National Labor Relations Board. She has also served as co-chair of the ABA Committee on Occupational Safety and Health Law. Ms. Reinhardt received her BA from the University of Michigan and her JD from Georgetown University. We're going to stop at this moment, and I'm going to introduce our ranking member, Congresswoman McMorris Rodgers, for her opening remarks.
Thank you, Madam Chairwoman, and I sincerely apologize for being late. We're going to do a better job since I have a terrible record here, and I am sorry I was over on the Senate side, and it just takes a while. Since today is recognized around the world as Worker Memorial Day, I'd like to begin my comments by acknowledging the family members who have come to Washington, D.C. to share their stories about loved ones injured or killed on the job. Yesterday, the House passed House Resolution 375, honoring those who lost their lives in the workplace. And I'd like to extend my deepest sympathies and condolences to them. Turning to the focus of today's hearing, I'd like to thank the chairwoman for providing another opportunity to further examine H.R. 2067, the Protecting America's Workers Act. We have before us a large panel of distinguished witnesses, and I look forward to hearing their expertise on two specific issues: whistleblowers and victims' rights. As I mentioned during our hearing last month, providing a safe workplace should be an employer's #1 responsibility. And it should be a shared responsibility, one that reflects partnerships between the federal, state, local governments, the private sector, employers, and other interested stakeholders. Notwithstanding these shared efforts, there's no doubt in my mind that workers should be able to report illegal or unsafe practices without fear. I don't think anyone here would have sympathy for an employer who did not take safety seriously. The provisions in the current OSHA Act that protect employees who report these illegal and unsafe practices from retaliation are the subject of today's hearings. I look forward to hearing from our witnesses as to how these protections are implemented, what changes are needed, why they are needed, and whether the changes proposed by H.R. 2067 are the most appropriate. I say this because with any legislative proposal, particularly one that changes long-standing policies, we have to be certain that we're not doing more harm than good. In addition, today's hearing will examine what's known as victims' rights, the information and cooperation afforded to those employees who are injured and families who have lost a loved one in the workplace. We will hear from one family about OSHA's failure to inform them of conclusions reached in fatality investigations, which is unacceptable. Current OSHA policy should have precluded this oversight, and I'm interested to learn why these policies were not implemented appropriately. Finally, I'd just like to thank the chairwoman for her interest in this topic, for giving us the opportunity to look more closely at workplace safety. This hearing is the latest in a series of hearings looking at the aspects of H.R. 2067, the Protecting America's Workers Act, and the broader issue as to how to keep Americans safe and healthy on the job. I look forward to a productive, lively debate this morning and yield back.
Thank you very much. And now, just for those of you who have not been witnesses in the past, I'd like to explain our lighting system. We will turn on a green light when you begin your testimony, which means you have 5 minutes. When the light turns orange, you know you have 1 minute left. And we would hope you would be wrapping up your testimony at that point. I assure you the floor does not open up. You do not fall into outer space if you get beyond the 5 minutes. But in order to keep the hearing going and have everybody have time, if you miss some point, then when it's the members are asking their questions, you can probably get to your point at that time. So now we're going to hear from our witnesses, starting from Secretary Barad.
Thank you, Madam Chair, and Ranking Member McMorris-Rodgers, and members of the subcommittee. I recognize the significance of today's hearing being held on the 39th anniversary of the creation of the Occupational Safety and Health Administration, OSHA, and Workers' Memorial Day. Today is a day set aside to recognize workers killed, disabled, injured, or sickened by their work. And today we meet under the shadow of 3 recent tragedies: the loss of 29 miners in West Virginia, 70 refinery workers in Washington State, and the 11 workers still missing from the Deepwater Horizon. Now more than ever is the time to think seriously and act courageously to ensure that OSHA has the tools it needs to enforce safe working conditions, and that this government provides workers and the victims the tools they need to help ensure those safe working conditions. Secretary Solis's vision for the Department of Labor is good jobs for everyone. Good jobs are safe jobs, but American workers still face unacceptable hazards. The administration supports the Protecting America's Workers Act, which would make meaningful, substantial, and long overdue statutory changes in the Occupational Safety and Health Act, providing OSHA with important tools to strengthen and expand its enforcement programs. 2 of the critical tools included in PAWA are the enhanced whistleblower protections and increased victims' rights. OSHA inspectors are not able to visit more than a small fraction of this nation's workplaces. The OSHA Act therefore relies heavily on workers to help identify hazards at their workplaces. The authors of the OSHA Act realize that employees are not likely to participate in safety and health activities if they fear they'll lose their jobs. That's why Congress wrote 11C to protect employees from discrimination and retaliation when they report safety and health hazards or exercise other rights under the OSHA Act. Without robust whistleblower protection, these voices may be silenced. POWA would strengthen 11C by providing workers with basic rights that other, more recent whistleblower laws passed with broad bipartisan support have provided workers. POWA would better protect a worker's right to participate in making those working conditions safer by providing workers with a private right of action, an important element that is lacking in OSHA's current 11C provision. We believe it's critically important that if an employer fails to comply with an order providing relief, both OSHA and the worker should be able to file a civil action. POWA will also grant workers the right to further pursue their case if OSHA does not proceed in a timely fashion, codify a worker's right to refuse to perform unsafe work, protect employees who refuse work because they fear harm to other workers, prohibit employer policies that discourage workers from reporting illnesses or injuries, and prohibit employer retaliation against employees for reporting injuries or illnesses. POWA would also increase the existing 30-day deadline for filing an 11C complaint to 180 days. Over the years, many complainants who might otherwise have had a strong case for retaliation have been denied protection simply because they did not file within the 30-day deadline. Finally, POWA would codify a number of OSHA's high standards for professionalism and transparency in conducting whistleblower investigations that are of critical importance to this administration. For example, POWA requires OSHA to interview complainants and to provide them with a respondent's response and the evidence supporting the respondent's position. POWA affords complainants the opportunity to meet with OSHA and to rebut the employer's statements or evidence. Turning to victims' rights, OSHA has long known that workers and often their family can serve as OSHA's eyes and ears identifying workplace hazards. Injured workers and their family often provide useful information to investigators because employees frequently discuss work activities and coworkers with family members. I want to thank Tanya Ford, whose uncle Robert Fitch was killed at Archer's Daniel Midland on January 29, 2009, for coming to Washington today to testify and describe the tragic circumstances of Mr. Fitch's death and the unnecessary problems that she and her family faced getting information about what happened. We appreciate her suggestions on how to improve our enforcement proceedings to better involve victims and their families. It's OSHA's policy to talk to families during the investigation process and inform them about our citation procedures and settlements. Families are normally provided a copy of the citations when issued. We found, however, that some of OSHA's policies on victims' rights have not always been implemented consistently and in a timely manner. It's also clear that a letter is not adequate. Therefore, we'll be strengthening those policies by putting them into a directive and adding them to the Field Operations Manual. We'll also be instructing our area directors to call the family to express condolences, advise that a letter is coming, and assure families that we'll be staying in contact. In addition, we'll be appointing family liaisons in every one of OSHA's 70 area offices. In general, OSHA supports the changes in POWA for victims and their family. Our only concern is that we find a way to both fully ensure family and victim participation without unduly burdening or lengthening the enforcement process. Madam Chair, I appreciate the opportunity today to discuss POWA and how it would improve whistleblower protections and victims' rights. I believe stronger whistleblower protections and more substantial rights for victims and their families can lead to safer job sites and ultimately more men and women who go home safely to their families at the end of the day. I'd be happy to answer your questions.
Thank you. Ms. Ford.
Dear Chairman Woolsey, Ranking Member McMorris Rogers, and Member of Committee, my name is Tanya Ford and I live in Lincoln, Nebraska. I would like to start off by saying thank you so much for this opportunity. It is a great honor to sit here and represent my family and other families who have lost their loved ones due to preventable work-related accident. I support the Protect American Workers Act because of what happened on January 29, 2009, when I lost my Uncle Robert Fitch, or as I called him, Uncle Bobby, to a horrible preventable work-related accident at the Archer Daniel Midland plant in Lincoln, Nebraska. My Uncle Bobby was 51 years old. Our lives changed forever that day when my uncle stepped onto a belt-operated man lift in order to go to his work break, fell approximately 40 feet. As he fell, he impacted each wall in the cement elevator shaft and landed on the air duct, hitting it so hard it slid 19 feet from the connection point. At that point, my uncle slid off and fell through a manhole and then fell another 40 feet to the cement ground below. My dad, Uncle Bobby's brother-in-law, found him that day. My dad still works at this ADM plant. Since that moment, my life has become filled with gathering dates, statistics, evidence, and information. I started my research to answer our family's simple questions. What happened? Did he suffer? Did the device malfunction? Was the device too old and unsafe for my uncle and other employees that work at ADM? Something went terribly wrong that day, and my cousin Jessica and Jeremy Fitch, my mom, and the rest of our family deserve to know what happened and why. I have come to the conclusion that if POWA had been passed when it was first introduced, my uncle might be alive 3 weeks ago to place a rose on his mother's casket. Instead, when my grandmother passed away last month, we placed a single rose on an empty chair where he should have sat. POWA is important not only because it included tougher penalties to discourage companies letting safety problems continue, but because it extended additional rights to family members. If POWA had been in place when my uncle died, my family would not have learned about the fines assessed against ADM from a local news reporter. When the television camera rolling, the reporter asked me, "What do you think about the penalties assessed by ADM?" I could only respond, we are not aware what the penalty is, and that the investigation was even closed. This is how our family learned that ADM was fined $0 for having an old and dangerous belt-operated man lift in their plant. This piece of equipment caused my uncle's death, and that I have since been informed it is inherently unsafe and very scary to use. A device that you should require specialized training before anyone should use it, and a device that causes many injuries and even deaths. Yet ADM received no monetary penalties for having this deadly equipment in their plant. We asked, why was ADM not fined from OSHA for the device that took my uncle from us? 9 months after hearing about 0 penalties assessed at ADM, my family still did not have the answers. I reached out to OSHA for answers in January 2010, and OSHA agreed to meet with us. I was ready to ask them all the questions that resulted in my months of research in belt-operated man lifts. To my amazement, I learned that OSHA issued 2 citations to ADM that were classified as serious and specifically related to the dangerous belt-operated man lift. However, as part of the informal settlement between OSHA and ADM, the 2 citations related to the man lift and the monetary penalties were deleted. When we asked why OSHA told us that these dangerous man lifts were not covered by an OSHA standard, under an OSHA standard issued in 1971, man lifts installed prior to August 1971 were grandfathered in, meaning that OSHA standard did not apply to them. OSHA explained that because of this grandfather clause, they could not uphold the citation if ADM contested it, but through their settlement with the company, ADM agreed to replace the belt-operated man lift that killed my uncle with an elevator. OSHA thought this was a good compromise, getting ADM to get rid of a highly dangerous piece of equipment and install something safer in its place. That's not good enough, and here's why. This ADM facility where my uncle was killed and where my dad still works had a total of 5 of these belt-operated man lifts, stating that only had to replace just one of them does not get rid of the problem. These man lifts are operating in other ADM facilities across the country. This equipment kills workers. A company like ADM with a stock market value of $18.31 billion should be compelled to replace all of these dangerous lifts immediately. I urge Congress to pass the Protect American Workers Act because it would improve OSHA's ability to ensure workers are protected from dangers on jobs. I support the provision to increase OSHA's penalties and have been routinely adjusted for inflation, but penalties are only effective if OSHA has the ability to compel abatement, even if the employers contest the citation and penalties. The Federal Mine Safety Agency has the authority for the 300,000 workers it covers, and OSHA needs it for the 111 million workers who rely on its protection. As a family, we believe if we are going to prevent more deaths and hurt, OSHA must be able to force abatement during the contest period. We strongly support all the provision of POWA, including the new rights that would be given to family members. We believe it is very important for OSHA to meet with the family or the representative before the agency finishes its investigation, and for the family to have the opportunity to make a victim's impact statement if in the case proceeds to the Occupational Safety and Health Review Commission. My Uncle Bobby gave 32 years to ADM, often working 7 days a week. My dad still works there, as do many other men and women. This month alone, we've seen too much deaths and grief because of preventable workplace hazards. If companies do not set the bar high enough for workers' health and safety, then OSHA must be empowered to do so. Thank you.
Thank you. Mr. Morikawa.
Thank you very much, Chairwoman Woolsey, Ranking Member McMorris-Rodgers, and members of the subcommittee, and fellow members of this panel. My name is Dennis Morikawa, and I'm a partner at the Philadelphia law firm of Morgan, Lewis, and Bacchius. I appreciate the opportunity to appear before you at this hearing to address the victims' rights provisions of the latest draft of the Protecting America's Workers Act legislation. I'm testifying today on behalf of the U.S. Chamber of Commerce, and my testimony and comments are not intended to represent the views of Morgan, Lewis & Bockius or its clients. On this very special Workers' Memorial Day, I want to assure that our thoughts and prayers are with the families of victims who have lost their lives on the job. I think it should be a common goal of all of us to prevent accidents and to end fatalities in the American workplace. And I share Ms. Ford's sentiment with respect to that issue. As I mentioned, I'm a partner with Morgan Lewis, having been with that firm since 1974, and during that time, I have practiced in the area of occupational safety and health law. As a consequence of that, I've had a good opportunity to see the inner workings of how OSHA works, both in the inspection, in the citation, the settlement, and the litigation process of OSHA cases. I've literally represented clients in hundreds of OSHA cases. However, the aspect of my practice in which I am most proud has been in providing the basis for the creation of coalitions of employers dedicated to cooperating for the purpose of ending accidents and fatalities on the job. I refer specifically to the work that I did with the Electrical Contractors Transmission and Distribution Strategic Partnership for Safety, better known as the ET&D Partnership, which represents a coalition of 6 of the largest union and non-union electrical transmission contractors in the United States, who in 2004 banded together to create a unique partnership which matched these contractors with the International Brotherhood of Electrical Workers, the National Electrical Contractors Association, and the Edison Electric Institute. The express purpose of that partnership was to bring about a substantial reduction in injuries and fatalities in the electrical construction industry and to create rigorous standards for best practices to be utilized by companies in that industry to bring about a real change in the industry's safety culture. In other words, to really make a difference. I am very proud to tell you that the statistics that have been done with respect to the success of this partnership indicate that between 2003 and 2009, fatality rates for ET&D partners declined by almost 80%, and the lost workday injury and illness rate for partners was reduced to a remarkable 0.89, which represents less than 1 injury per 100 workers in an industry which had long been characterized by OSHA as a high-hazard industry. It demonstrates that when a coalition of employers and labor and employees and associations get together for the common purpose of ending accidents, stopping injuries, and stopping fatalities on the job, it can, in fact, be effective and be a 21st century model for new safety and health approaches. Now, let me make it clear today that my brief comments are intended to focus solely on the issue of victims' rights in Section 306 of PAWA. And as many of you are aware, the Chamber has made previous comments earlier on March 16th with respect to broad aspects of this legislation. It is important to point out that the basic substance of victims' rights as set forth in Section 306 of PAWA is in many respects a codification of existing procedures already set forth in OSHA's Field Operations Manual, or the FOM or FOM as it's referred to. I think Deputy Assistant Secretary Jordan Barab did an excellent job in talking about and summarizing the OSHA procedures that have been in effect for over 15 years, which address communications with and the provision of information to victims and their family members. And we commend Mr. Barab for his recognition that some of the FOM policies have not always been followed by OSHA consistently and in a timely manner, and Mr. Barab has pledged to place new policies into a directive and to make new amendments to the FOM to address these issues. Mr. Barab also states that OSHA will be revising their training of compliance officers to address interactions with victims' families. We applaud OSHA's initiatives in that regard. But in contrast to the FOM procedure, Section 306 now provides that victims and their family members are to be given the right to meet with OSHA prior to OSHA's decision to issue or not issue a citation, and requires that prior to OSHA entering into any agreement to settle a citation, OSHA must notify the victims or the representative of the victims about the settlement meeting in order to give the victim or their representative an opportunity to appear and make a statement in front of the parties conducting those settlement negotiations. We agree with Assistant Secretary David Michaels' view expressed on March 16th that victims and their families desire to be more fully involved in the remedial process. But we also agree with Dr. Michaels' comments given to the subcommittee in which he urged that clarification was needed with respect to Section 306, particularly as to the provisions allowing victims and their representatives to meet in person with OSHA before the agency decides to issue a citation, and also to make statements at contested hearings that follow. Dr. Michaels has pointed out that this could create logistical difficulties for victims as well as OSHA's regional and area offices, which could result in significant delays in the negotiations and ultimate resolution of cases, which, according to Dr. Michaels, could hurt the victim and their families in the long run. Deputy Assistant Secretary Barab's comments today strongly support that point. In addition to the issues identified by Dr. Michaels, we would add that Section 306 is made potentially more problematic by the provision for the involvement of representatives of the victim, as that term has not been defined specifically in the section. While Section 306 does define victim and family member, the section does not make clear what representatives are contemplated within 306. Now, Tanya Ford's moving and eloquent tribute to her uncle this morning is an excellent example of where a family member represents the deceased loved one in conveying the thoughts and emotions of her family, and we thank her for those comments. However, we would submit that further clarification needs to be made with respect to whether the quote, representative of the victim contemplated by this section is intended to be somebody other than a family member, such as an attorney, for example, the involvement of which may, in the concept of Assistant Secretary Michaels, create delays that could hamper the process. In conclusion, we urge this committee to more clearly clarify the rights, duties, and responsibilities of the entities covered under discussion in draft Section 306, which purports to address victims' rights, and to determine if Section 306 truly advances the interests of safety and health through a fair, efficient, and prompt resolution of matters before OSHA and the Commission. We would point out that OSHA needs the opportunity to exercise prosecutorial discretion with respect to the matters that they handle. They are an understaffed agency with a very, very big mission. We support their efforts, and we hope that they will continue those efforts towards ending accidents and fatalities on the job. Thank you.
Thank you very much. Dr. Monforton.
Chairwoman Woolsey and members of the subcommittee, I'm Celeste Monforton, an assistant research professor at the George Washington University School of Public Health. I appreciate the opportunity to be here today and ask that my written statement be made part of the hearing record. One of the most rewarding and enlightening experiences of my public health career was my involvement in 2006 in the Sago mine disaster investigation, and some of those family members are here today. I came to understand and appreciate that family member victims can make a meaningful contribution to the accident investigation process. I heard then, and I still hear today, that family members will impede the investigation, that family members have a conflict of interest, or that family members are just too emotional to be useful in fact-finding. My experience tells me that nothing is further from the truth. With Sago, no one paid closer attention to the details, pressed the investigators harder for answers, and raised the bar higher for mine safety reforms. I would relish the opportunity in the question and answer period to respond to Mr. Morikawa's comments about having attorneys representing family members. It's my experience working with the Sago families and other family member victims that inform my views today. OSHA does have a long-standing policy related to victims' families. From my experience, however, the objective of that policy is vague, leading to vastly different experiences among family members depending on the OSHA area office or the state plan. A condolence letter sent to the wife of Ray Gonzalez, for example, was mailed to her in September 2004, after he suffered burns at the BP Texas City facility. Mr. Gonzalez, however, did not die until November 2004. In addition, in the second and third paragraphs of the letter, it does not mention her husband, but a different deceased worker. Gross and insensitive errors such as this do not give families much confidence in the quality of OSHA's accident investigations. In my testimony, I described the experience of Maureen Rivetta, whose husband was killed in September 2009. No widow should feel incompetent for not understanding or comprehending OSHA's procedures. It should be OSHA's duty to make sure that family members understand their procedures, taking into account how shock and grief can affect one's ability to process information. I also heard at last month's hearing the witness representing the Chamber of Commerce asserting that involving family members does not appear to add much value other than to sensationalize. That comment is terribly uninformed, particularly of the reality of what families can offer to investigators. Speak to any of the family members present here today. They will impress you with their knowledge of the factors that contributed or caused their loved one's death, and their suggestions for ways our worker injury and illness prevention system can be improved. PAWA could go further and build on provisions for a family liaison as contained in the Minor Act of 2006. Family liaison requirements must be strengthened and elevated to statutory duties of the agency. Rights for family members and injured workers are too important to be contained in policy. I fully support PAWA's provisions to reform the whistleblower protections in Section 11C of the OSH Act. When I worked at OSHA in the early 1990s, it was apparent to me, a newcomer to the Labor Department, that the 11C program was a stepchild of the agency. The whistleblower witness here today, Mr. Neil Jorgensen, is an excellent example of why individuals should not be held captive because of the Labor Department's failures. Whether the problems at the DOL are resource constraints, lack of interest, litigation anxiety, or their client is a secretary, not the claimant, health and safety whistleblowers must be afforded a private right of action to pursue their case. At one time, I thought that the whistleblower protection functions delegated to OSHA could be at the heart of a health and safety protection system, but I no longer believe that to be the case. The subcommittee should consider a bolder reform to improve protection for whistleblowers. I applaud your efforts, Chairwoman Woolsey, and your leadership on this crucial issue, and I support your proposal from the 110th Congress to create a separate independent agency to administer all federal whistleblower statutes. Vigilant defense of workers who exercise their whistleblower rights, especially issues related to health and safety, is fundamental to an effective occupational injury and illness prevention system. I'm pleased to answer your questions.
You get the prize. You didn't even go all the way for 5 minutes. We'll get you later. Mr. Jorgensen.
Thank you for inviting me here today. My name is Neil Jorgensen. I live in Preston, Idaho. I became a whistleblower after being fired by Plastic Industries for filing a complaint with OSHA about the company's safety problems. Here are some things to think about while I'm giving my testimony. If you were my friend and you had violations in your workplace, and you came to me and asked my opinion, I would say, work safe, look for a new job. You work safe so you don't get hurt, and look for a new job because it will cost you your job and twice as much as it cost the employer. The company fired me 2 weeks after I filed the complaint because OSHA went to the company and conducted a safety inspection and found 8 safety violations, including 2 considered serious by OSHA, and one for not having machine guards on a bandsaw, and one for not having proper shut-off controls on a baling machine and a pressure washer. After the company fired me, I filed another complaint with OSHA known as the whistleblower complaint. Filing that complaint did not work out well for me. I was protected by OSHA law. I was not protected by OSHA law. The reason I'm here to tell my story is that my employer got away with firing me without any consequences. Although OSHA investigated the facts of my case, found it was sound, and tried to collect the wages I would have earned if I had not been fired, the government lawyers decided not to take my case to court. Under OSHA law, only the government can take these cases to court. That does not seem fair to me. It also does not seem fair that the only thing that the owner of the company, Rex Pitcher, was asked to pay was the fines for the violations OSHA found during its safety inspection, and those fines were later reduced a lot. OSHA initially asked the company to pay $2,550, but it was later reduced to $1,500. OSHA recommended the government lawyers take my case to court, but they decided not to. The main reason they gave was a resource-intensive case, and 2 judges in Idaho who would get these cases were not likely to decide in their favor. I was advised that lawyers sent a memo which says, We believe we have an approximate 25% chance of success. There are 2 U.S. District Court judges in Idaho, one of whom routinely is not well disposed towards government cases, and the other who can go either way. It is sad to me that the company could treat an employee this way and get off scot-free. Isn't it the purpose of the whistleblower laws to protect workers who report unsafe conditions? I thought I did the right thing, but the system did not work for me. The OSHA law did not provide the protections I needed, and the only lesson the owner of the company learned is that he can treat his employees any way he likes, then lie about it, and nothing will happen to him. Nothing. Would I recommend that someone would file a whistleblower complaint? No way, absolutely not. The way the law is written, not a chance. I have found in my life, for something to really make an impression, it has to have teeth in it. When I was 5 years old, I followed some friends on my trike up to a pond to go frog hunting. My parents found me on my tricycle, and my tricycle got a ride home with Mom. I got to ride a switch home in front of Dad all the way home. The next time I went to that pond, I was about 11 years old, and it was winter. No chance of drowning there. I think OSHA needs a switch. Something with some teeth in it. Thank you for letting me tell my story. I hope you're able to do something to improve the OSHA law that is supposed to protect workers.
Thank you, Mr. Jorgensen. Mr. Chin.
Yes, thank you. Good morning, Chairwoman Woolsey.
I don't believe you've got your microphone on. If you do, put it closer to you.
Is that better?
Yes.
Does that work now? My apologies for that. If that's the worst trouble I get into today, that would probably be a successful day. In any event, I'll start again. Good morning, Chairwoman Woolsey, Ranking Member McMorris-Rogers, members of the subcommittee, my fellow panel members, and representatives of employers in the audience, as well as the individuals in the audience who are family members of those who have been killed or injured terribly while working on the job. My name is Lloyd Chen, and I am a partner at a law firm, Proskauer Rose. I practice labor and employment law. I advise employers as to what they need to do to comply with the laws. I litigate disputes between employers and their employees. A significant component of my practice is the litigation of what may generically be referred to as whistleblower or retaliation claims. And it is a privilege and an honor for me to speak with you today about this important topic, this topic as it is addressed in the Protecting American Workers Act, or as I believe we have license to call it from the Chairwoman, PAWA. I'm going to focus on Title II of PAWA, which I think we would all agree completely rewrites the current Section 11C of the OSHA Act. The first question for me is what exactly is motivating this complete rewrite of the statute? I mean, at the end of the day, it may well make sense to do some of this, but I think it is an appropriate question at the outset to pose. The purpose of the statute, as stated in the statute and as everyone on this panel would agree, is to advance workplace safety. It is not to promote employment litigation. This is not an employment litigation statute as such, like Title VII of the Civil Rights Act. The claim apparently is that the current whistleblower protections in the statute are inadequate, but what is the evidence to support that claim? There are something like 1,200 to 1,300 claims per year made under 11C of the OSHA Act. And while it tugs at the heartstrings to listen to Mr. Jorgensen's story, and I admit that, I don't think it's appropriate to formulate policy based on one example, or perhaps an example in Ms. Reinhardt's paper of a Mr. Wood who had an incredible odyssey through the legal system that lasted in something like a decade in the 90s, I don't think it makes sense to base policy involving thousands of claims made per year based on minimal anecdotes, a minimal number of anecdotes like that. And while it may be unpopular to say this in this room, for every example like Mr. Jorgensen's, there are hundreds of meritless claims filed per year. And everybody, if people are being honest, Mr. Barab, the current, who's currently in this role at OSHA, will agree that the overwhelming majority of claims measured by any objective standard filed with OSHA are meritless. And for that matter, that is true for virtually every statute, employment statute on the books. And there really is no disputing this. Now, again, this story about meritless claims and the expenses associated with those claims or defending those claims is not the sort of story that's going to bring a tear to your eye, as did Ms. Ford's as I was listening to it. But in a time when we have approximately 10% unemployment in this country, it strikes me that it is at least relevant. It is at least worth putting into the mix, into the arguments being considered. Every action you take, like these whistleblower protections in PAWA, will be an additional expense to employers. That is, it will make it more expensive to employ someone should you enact these provisions. Now, you may decide, as one might be willing to do, that it's worth it. But I think that it's at least worthwhile to have that issue on the table. And the way in which, the primary way in which PAWA will increase the expenses of litigation is that PAWA bestows significant new rights of action on 11C complainants. PAWA simultaneously provides Section 11C whistleblowers the opportunity to take their claims to the OALJ, the Office of Administrative Law Judges, or to the Administrative Review Board, and sets very tight timelines within which those bodies must reach final decisions on those claims. This is not realistic. Of the total whistleblower claims under all statutes addressed by OSHA per year, those filed under 11C account for a large majority, approximately 65% in 2007. This is a potential tripling of the pool of cases that will be going through the OALJ and ARB system. And I am unaware, although Mr. Barrett may be able to address this, of any plans to expand those bodies in any significant fashion to address these additional claims. So what this means in reality is that every OSH whistleblower will really have an immediate right to go to court, because OALJ and ARB will never meet these timelines that are in the statute currently. And nobody in this room can debate that. I really don't think that is a debatable point. Liberal academics writing in the field agree completely with what I am saying right now. So what we have here is this logjam that already exists in the OALJ and ARB that will be worsened dramatically by the addition of new cases. So everything goes to federal court then. My understanding is that there is a lot of criticism of the time it takes for these complaints to be addressed. Well, for those of you who litigate in federal court in this room, I assure you that the federal litigation process is not the most efficient for resolving disputes of this matter. It is very lengthy, very time-consuming, and very expensive. If you look at the GAO's recent report, interestingly enough, the most efficient procedure described in that report is the appeals committee that addresses 11C complaints. That appeals committee addresses matters on a far rapid, far more efficient basis than either OALJ, ARB, and certainly the federal courts. In closing, I would simply ask the subcommittee to maintain an open mind with respect to certain particulars of the statute, which we will be talking about more during the course of the hearing. Thank you very much.
Thank you. Before we go to Ms. Reinhardt, those with placards, you need to hold them down, and please don't stand up. Thank you very much. I mean, you know, in front of you, but just not up. Thank you. Ms. Reinhardt.
Thank you, Chairman Woolsey. and Ranking Member McMorris-Rogers and the other members of the panel for holding this hearing and for inviting me here today to testify on the need to strengthen the anti-retaliation whistleblower protections in the Occupational Safety and Health Act. My name is Lynn Reinhardt. I'm the General Counsel of the AFL-CIO. We're a labor federation representing about 11 million workers across the United States, and we are in strong support of the Protecting America's Workers Act and the provisions in it to strengthen the penalties and strengthen the whistleblower protections in the law. We really appreciate your holding this hearing today on Workers' Memorial Day, a day when we honor and pay tribute to workers who were killed on the job, and I want to acknowledge the family members who are here on the panel and here in the room and express our sympathies for their loss. We're all here for the same reason, which is that we believe strongly that those fatalities should not have occurred in vain, and that we need to redouble our efforts to take measures, strengthen the law, do what we need to do to make sure that further fatalities don't happen in America's workplaces. And frankly, we have a lot of work to do. Still today, 5,000 workers, more than 5,000 workers, die on the job each year. That's 14 workers each and every day who are killed from workplace hazards, and millions more are injured. 5,000 workers a year is the population of many small towns across America. And it's that number of workers killed on the job each and every year from workplace hazards. It's just an unacceptable level of tragedy in America's workplaces that we have much work to do to address. I think everybody on the panel would agree that in order to address workplace hazards and to try to get preventive actions in place before injuries, illnesses, and fatalities occur, that you need the full and active involvement of workers. Workers are the eyes and ears in the workplace. It's their jobs. They see the hazards. They know the hazards. They know what solutions might be put in place to address those hazards. And so employers who are being proactive about health and safety in their workplaces want and need the full and active involvement of their workers in identifying and raising hazards. And especially given the fact that OSHA can't be everywhere at all times. In fact, it would take them 137 years to be in each workplace just once. All the more reason why we need the active and full involvement of workers in identifying hazards and protecting their health and safety on the job. In order to have that active involvement, workers need to feel secure that if they raise a hazard, if they bring a concern forward, if they file a complaint with OSHA, that their jobs are going to be secure. They're not going to be fired or demoted or transferred or suffer other retaliation for speaking out. The system really depends on that. And unfortunately, we don't have that situation today. As Mr. Jorgensen's story so painfully shows, workers today do not have a right to speak out about job hazards without retaliation and have a remedy behind them for speaking out and pursuing their rights. It's even more important in today's bad economy that the law be strengthened. The fear of retaliation, the fear of losing one's job is even more intense when you're looking at an almost 10% unemployment situation, and that just exacerbates workers' fear of speaking out. Workers who are covered by a union contract are in a better position because they have their union in that contract backing them up if they suffer retaliation for reporting job hazards. But unfortunately, that's a protection that's only afforded at this moment to a minority of workers in America's workplaces. So most workers are left with the protections of the Occupational Safety and Health Act, and these protections by any measure are exceedingly weak, and they are the weakest of any of the 17 laws that OSHA, whistleblower laws that OSHA itself enforces. How ironic that the weakest law enforced by OSHA is the OSHA Act. I attached a chart to my testimony that laid out some of the ways that the OSHA Act's anti-retaliation whistleblower protections fall short of the standard laid out in so many other laws, including Sarbanes-Oxley, including the Surface Transportation Act, including the recent health care reform that was adopted. By any meaningful measure, the OSHA Act's whistleblower protections fall short of the mark. The statute of limitations is exceedingly short, only 30 days. There's no right under the OSHA Act for workers to get their jobs back for preliminary reinstatement while their cases are pending. And they have no right to get a hearing before an administrative law judge or a court. They're completely dependent on the Secretary of Labor bringing their cases forward, and as we've heard, that rarely happens. and the burdens on the Department of Labor are significant as well. They can't pursue an administrative process themselves. They need to go to federal district court to pursue these whistleblower cases in court. So the law is extremely weak. There's a saying in the law that rights without remedies are really no rights at all. And frankly, that's what we're talking about here with the whistleblower protections in the Occupational Safety and Health Act. The provisions are so weak as to really be meaningless. So we support the provisions in the Protecting America's Workers Act. We think that they would make a real positive difference in protecting workers' ability to raise safety and health hazards on the job. It would update the law, bring it up to par with other anti-retaliation protections and other laws, including laws that have been passed over the past 5 years with bipartisan support and signed into law by both Republican and Democratic presidents. We think that these measures would give workers more meaningful rights to participate in safety and health on the job and bring about preventive efforts before injuries, illnesses, and fatalities occur. I'd like to make just two other brief comments in the time that I have. One is that while we fully support the provision in the Protecting America's Workers Act that would give workers a right to pursue their own case before an ALJ or a federal court if the secretary did not pursue their case or if the case was proceeding too slowly, we don't view that right as a substitute for the Secretary of Labor still having her own robust anti-retaliation whistleblower program. We think you need both. You need the agency program and you need the private right of action. The other comment I would make is that it really seems to me that employers ought to support the provisions, the anti-retaliation provisions in this legislation, because employers who want their workers to feel secure speaking out about job hazards should support there being a law to back workers up when they do step forward and exercise those rights. These are modest measures. They're not novel. They're not radical. They would simply bring the OSHA Act into the mainstream and make it more uniform with other anti-retaliation whistleblower laws that have been passed by Congress over the years. So we think it's necessary. We think it's overdue. And we urge their prompt adoption. Thanks very much.
Thank you very, very much. I need to say before we start our questions, I have two committees that are both marking up legislation. So if I get up and leave, I'll be back, and it's because I have to go vote at another committee. And one of our members will take the chair. So please don't take it personally. But so far, so good. So I'm going to begin the questioning with you, Jordan. At last month's committee hearing on OSHA penalties, Assistant Secretary Michaels testified that OSHA had reservations about certain victims' rights provisions in PAWA, namely allowing a family member to meet with OSHA before the agency decides to issue a citation, and family members appearing before the parties conducting settlement discussions. You've also reiterated this in your testimony today. So, you know, the family members are here. You've heard from them. We can't question whether what we're doing is necessary or not necessary. What we want to find out is how to do it so it works for them and doesn't get all bogged down. We've learned some things from MSHA. So, how have we? You know, how does the MSHA's experience relate to your reservations, and how can we settle those reservations, or do we need to continue discussion on it? But what would you think would be the best way?
Well, first of all, let me clarify. Dr. Michaels expressed. I'd say we have, not even reservations. We have some concerns. We obviously need the law, and everybody needs the law. Workers' families to work as efficiently as possible. But I want to reiterate that we fully support family involvement. We fully support the provisions in this law. In fact, we are, already going to be implementing some of the provisions of this law even before it's passed, which we hope will happen soon.
Thank you.
So our statements of concern, are in no way, should in no way communicate that we're not fully in support of this or fully in support of family participation. We do want to we have been actually talking to MSHA. We realize MSHA's learned some important lessons, certainly from Sago and Crandall Canyon, on how to relate to families and how this can be done best. And we will be talking to them. We are talking to them. We will be talking to them more, and we will be learning from them. We learn an incredible amount just from the families that are here today. They came into town. They talked to Secretary Solis yesterday. We're in frequent contact with them. We have already, told our field staff not only to make sure that we implement what we already have consistently, but we will be actually, again, assigning OSHA staff to be family liaisons. And we do want to improve the way we're doing things, and again, we fully support what's in the law. So I don't want it to be taken because we have expressed some concerns that this work right, that we don't have full confidence that can be done either through the law or through the regulatory process.
Okay, I hear that, but tell us what needs to be fixed to work right, with the idea that this administration follows 8 years of not giving a hoot. So how do we make sure we put into place the right programs,
well,
the
let me
policies
give you some examples that were raised.
will carry on from administration to administration.
Okay. It was one example that was raised today that Ms. Forrest raised, which I think was quite legitimate, that she and her family found out about the settlement we reached with ADM through the news media. Now, we followed the letter of our instructions in informing the family immediately, but by inform we meant we dropped a letter in the mail. Obviously that was not adequate. That was, in retrospect, particularly inexcusable. That is no way to inform a family of a settlement. And we are going to be changing that, and we are going to be redefining the word inform to you call them, you call the family, you talk to the family before the media is notified, certainly. We are going to be doing training for our field staff to make sure that they are comfortable. Some of the problem we have is people, understandably, are just not comfortable dealing with family members who are in the midst of tragedy, and we're going to be dealing with that as well. So there are a number of actions we're going to take, a number of things we're learned, and we have been learning. And again, we fully support what you're doing here.
Ms. Congresswoman McMorris-Rodgers.
Well, again, just let me say thank you to everyone for being here. Your testimony is extremely helpful to us as we are working on this legislation. And the previous administration, the 8 years before this administration, I believe that we actually saw both injury and workplace-related death rates decrease. And as I sit here, I think that part of the key is making sure that we have better partnerships between everyone that is involved and working together, because we do have a shared goal, and not make it adversarial. Mr. Jorgensen, I wanted to ask, because I understand that these whistleblower complaints are to be anonymous, and I just wanted to ask how you think your employer learned that you were the one that had brought the case forward.
Previous to my blowing the whistle.
Do you have your microphone on, Mr. Jorgensen?
I thought maybe we'll just, previous to my turning the complaint, my wife and a friend of hers had worked there, and they quit quite fiery. And when the complaint come down, it was kind of I think it was kind of obvious that the route that it came from. They were disgruntled. I was upset because I had talked to a couple of the employees there who had their finger caught in the bandsaw, which was my concern. But I think it kind of figured it out because my wife and her friend had quit.
Okay, thank you. Mr. Chin, your testimony highlighted the many provisions in the draft legislation that would make changes to the current whistleblower system. Are there any provisions that you believe merit more attention?
Yes, I do. Am I on? Yes, okay. I'm sorry, I can't seem to figure that out. Yeah, thank you for that question, because I think there are a couple of areas that even if you accept everything that's been said so far in the testimony, I think there are a couple of areas here that deserve some attention, and maybe it's the sort of attention that only a lawyer who lives these kind of phrases and words and provisions in litigation, you know, can appreciate, I suppose. One area that I think deserves some particular attention is the limitations area, that is the statute of limitations. And I will save for last my comments on what's been the focal point so far, and that is simply the increase in the period from 30 to 180 days. What I'd like to focus on first is, in this statute, there is a novel, at least as employment law goes, insertion of something that lawyers refer to as a discovery rule for the purpose of commencing the limitations period. That is, the limitations period begins either within a certain period of the alleged violation itself, that's the norm, or the date on which the employee knows or reasonably should have known that such a violation occurred. And it's that second component that I think is troubling. To my knowledge, it is a foreign concept in employment litigation completely. It is a vague and uncertain standard, and moreover, it doesn't really make any sense in the context of retaliation and whistleblowing. It might make sense in the context of like a medical malpractice case where a surgical instrument is left inside a person and it's not discovered for years afterwards. But here we're talking about, in the whistleblower context, think about what Mr. Jorgensen described. We're talking about cause and effect. We're talking, and that's the crux of a whistleblower complaint. That is, I complained and something happened to me because of that complaint. It's not a mystery. There's not some mysterious, if it really is true, if whistleblowing, if someone is being fired because they're a whistleblower, there's going to be some temporal connection between those concepts. So there's no need for it. Even if this weren't foreign to employment law, there's no need for it here. Secondly, with respect to the limitations period provisions in the statute, there's an extremely broad continuing violation provision lurking behind a heading called repeat violations. And essentially what that means, as written, is if you have one timely...
Finish your thought.
Okay. If you have one timely complaint to make, you may also complain about any untimely complaints that you want to, going back as many years as you want to, relating to any sorts of incidents, prior complaints, prior actions you want to.
Okay. Mr. Hare.
Thank you, Madam Chair. Mr. Chin, I don't know if you noticed when you were testifying, but several of the people in the audience were holding up pictures of their families, family members. I want to be very honest with you. A couple times, you know, you were talking about the expense to the employers and things of this nature, and that this, you know, about the numbers of meritless cases. It would seem to me, from my opinion, that looking at these families, these are sisters, brothers, husbands, wives, dads, grandfathers. We just lost 29 minors because you had an employer that cared more about profits than he cared about keeping the people safe, and we've had 4 of those. And I have to be honest with you, I don't know, I'm much less interested in the expense to the employers to keep their workers safe than keeping the workers actually safe. I mean, I think that every employer has a responsibility, and I think every worker has every right to assume that when they go into work every day, that they're going to go to work under safe circumstances as best they can, and be able to come home to their families. I don't think it's rocket science. I also think that when you talked about referred to Mr. Jorgensen's case, Here's a guy that saw something and reported it and lost his job, and then he was told, you can't even, basically, because you got a couple of lawyers out there, you probably are going to roll the dice on whether or not you're going to be able to prevail in your case. The system is upside down. It is completely upside down. I would much rather look at the statistics, as was mentioned, that 5,000 people every year die in this country. And I think there are a number of good employers in this country, but they have an obligation, those that aren't, to clean up their act, and if they don't, they shouldn't just be fined. They ought to end up in prison if they're not going to change what they're doing, the way they're acting. They'd rather pay fines than keep people safe. I think that's, I don't know. I don't know how these guys can go to sleep at night, to be honest with you. But I just want to ask, if I could, the person from the FLCIO, you were kind of shaking your head when some of that was being testified about I'm sorry, Ms. Reinhardt, the testimony that will lead to excessive litigation and false claims and those kinds of things. I wondered if, you didn't get an opportunity to, but, this is you can probably tell this is a very emotional issue to me. I came out of a factory. I'd like to hear from your take, maybe to respond to what Mr. Chin had to say. Because maybe I got it wrong, but I was shaking my head too, to be honest with you.
Thank you for the opportunity to address some of those points. I tried not to shake too hard, but I couldn't help myself. A couple of things. In terms of the concern that actually giving workers a remedy for these rights would lead to false claims, I completely disagree. Workers are not going to file these claims lightly. Filing a claim about retaliation with the government is a big deal. Workers know that they can lose their jobs. They know that these cases take a long time to be pursued. They know that there's no assurance that they're going to win at the end of the day. What we get in this legislation is workers get a fair shot. They get a fair shot to bring their case forward and to try to prove up their case, which is much more than they have right now under current law. There's the information that we have shows the problem isn't frivolous claims. The problem is workers don't have the right now to bring forward their claims. And that's the problem that the PAWA legislation is seeking to address, and the reason why we fully support it. If I could just say a word about the notion that the statute of limitations in the legislation is somehow an outlier and bizarre in the area of employment law. That's just not the case. The discovery rule that the statute of limitations is from the time of the act or from the time the victim discovered the act is well settled in employment law, in Title VII law, even under the Occupational Safety and Health Act for whistleblower cases. And so it's just not accurate to say that this is a novel or bizarre concept in the area of labor and employment law. If I could make just one final point, which is one of the premises of Mr. Chin's testimony seemed to be that whistleblower protections don't have anything to do with safety and health. They have to do with employment litigation, but they don't have anything to do with worker safety and health. We couldn't disagree more. We think they have everything to do with workers feeling secure to speak out, raise hazards, and be involved in protecting their health and safety on the job before injuries and illnesses occur.
Well, I know I'm out of time, but it would just seem to me that if Mr. Jorgensen or any worker sees something that's dangerous, that could be harmful to people that they work with, and they report it, and they get fired for doing that, A, that is obscene to fire the person, and B, if the employer, it doesn't allow the employer to do anything to correct the problem for the people that are there in the plant or wherever to keep them out of harm's way. It makes absolutely no sense to me.
Ms. Shea Porter.
Thank you very much. I have several concerns that I heard in front of me. First, I'd like to start, Ms. Ford, and say I'm very sorry about your loss. And I wondered if you have spoken to other families that are in the same situation, and do they feel like they've been shut out?
I have spoken to many of the families behind me. I have spoken to many families in Nebraska. Many of families that I've spoken to an individual that actually fell from a grain elevator after my uncle passed in the accident. And they said, we can't come forth because he still works there. And I don't think that's right.
So you think having a voice and allowing you
Yes.
to speak early would help other families as well?
Oh, yes. I mean, from day one after this accident, I started my research, and there was so much I had found out. And if I had understood about the whole 6-month time frame, this outcome would have been so different. I mean, I sat at my kitchen table and spoke to the OSHA representative and said, no, this was not grandfathered claused in. And it wasn't. I was right. And I find out in January 2010 that I was right. And nothing, it could have been prevented. Things could have changed.
If you could have had a voice at the
Yes.
table. Okay, and Dr. Monforton, what about that 8-hour rule that they have, that they don't have to report a death or something that could have led to a death in 8 hours? What's your concern about that?
That's a very big disparity between the Mine Safety Act and the OSHA law. Under the Mine Safety Act, it was immediate notification of a fatality, which was fuzzy language. So after the Minor Act passed, they stipulated it was within 15 minutes of the employer learning of the incident, not just of a fatality, but of a serious injury that is likely to cause a death. And under the OSHA statute, it's 8 hours for a fatality, which for many reasons is problematic, including, you know, the employer could actually change the scene of the crime, so to speak. And also under OSHA, it is only if there's 3 or more people that are hospitalized. So there are huge disparities between the two statutes, and I think something that this subcommittee could look at is how do we take some of the things that are terrific in the Mine Act and extend them to all workers, and vice versa, OSHA to MSHA.
And in all fairness, it could be accidental where they don't realize over the 8-hour period of time that they are changing or interfering with some evidence. So it could be accidental, simply trying
Right,
to
not necessarily
clear things
intentional. They
up.
may be just, you know,
Right.
cleaning up the scene.
But the point is that the evidence should be intact, I think is what you're getting at.
Exactly. So as soon as OSHA knows, you know, if it's the type of thing they hear the initial information, they may want to give the employer some instruction about what to do or not to
Right.
do.
Okay, thank you. I also had a question for you. The U.S. Chamber of Commerce testified at a recent hearing that small businesses should have the right to recover attorney's fees from employees who file whistleblower claims and then fail to prevail at a hearing. Do you think that would have any kind of chilling effect? Do you have any concerns about the loser having to pay?
Yeah, I think it's clear it would have a chilling effect if workers already face enough intimidation about filing complaints. And I think the fact that they not only might lose that or be fired due to a failure to sustain a whistleblower complaint, but to think that they also might be essentially fined for that I think would have a chilling effect. I mean, we don't want to just allow workers to file whistleblower complaints or file health and safety complaints. We want to encourage them to do that. And this goes in exactly the opposite direction.
Right, thank you. Do you agree, Mr. Chin?
Do I agree as to attorney's fees provision?
Yes.
As PAWA is written, I don't see that there's any possibility of an employer recovering if the employer prevails. Of course, in federal court, if the action proceeds to federal court, the matter would be governed by Rule 11 of the Federal Rules of Civil Procedure. If the matter were frivolous, an employer could recover attorney's fees under that provision.
But I wondered if you just agreed with the Chamber's perspective on that.
Well, if what Ms. Reinhart said was true, I don't agree with what was just stated. Ms. Reinhart said that employees will not bring forward meritless claims. Now, we know statistically that that's just an incorrect statement. I mean, even under the Obama OSHA, claims are rejected as meritless. But if Ms. Reinhart were accurate, then claimants have nothing to fear because they will always win under this legislation. Therefore, there should be, at least for small businesses, or at a minimum if the matter is frivolous or brought in bad faith, there should be some provision for attorney's fees, but nobody here should be concerned about it because, as Ms. Reinhart said, no action will ever be brought without merit.
And in all fairness, then you would also have to say that since cases are found to be meritless, that there's enough protection in there for business as well. Thank you. I yield back.
Congressman Payne.
Thank you very much. Mr. Barb, looking at the testimony, although I didn't hear it, but Mr. Jorgensen testified that he had filed a complaint with OSHA regarding unsafe working conditions, and he was terminated a week after the inspection. Despite the employer claiming that he was fired for poor performance, the OSHA inspectors discovered that the employer altered job performance documents, which they gave to OSHA, omitting anything positive about Mr. Jorgensen. So I guess my question is that, is it correct that OSHA investigators found that Mr. Jorgensen's case had merit? And if so, did Mr. Jorgensen have a strong case? And how do you feel about the way the law treats Mr. Jorgensen and other people like him?
Thank you, Mr. Payne. Yes, OSHA did find merit. OSHA found that it was a strong case, and as Mr. Jorgensen related, the solicitors decided not to litigate that case. Quite frankly, I'm appalled by this. I'm appalled that in the 21st century, 40 years after the Occupational Safety and Health Act was passed, that workers still have to be afraid to exercise their rights under this law. I'm not going to sit here. I mean, we did find merit. The solicitors didn't take it. I'm not going to sit here and certainly condemn the solicitors. They have their own priorities. They have their own resource decisions. They have to, make some very difficult decisions about this, and I'm sure it hurts them as much as it hurts us that this wasn't taken forward. The fact is, though, that we're both us, OSHA, the solicitors, and certainly workers are operating in what's now basically a dysfunctional system. It just doesn't work. And what we're asking you to do, what PAWA is asking you to, what PAWA would do is really fix that system so that workers actually have a chance to exercise their rights under the law and succeed if they are discriminated against for that.
Just since you brought up the solicitors, let me ask you this, and you indicate they have a tough time, but over the past 14 years, the solicitor's office has brought suit in only 7% of the 467 merit cases it sent to OSHA, and declined to prosecute 60% of those cases. Is Mr. Jorgensen's case an isolated one, or do you believe there are other meritorious claims which have been left by workers who were left really without any real recourse, sort of left high and dry? Why do you feel that the solicitor's office has such a low rate of success?
Well, I think clearly Mr. Jorgensen's case is not an isolated case. There are many cases on those. The figures speak for themselves. And I'm not with the solicitor's office. I'm not going to really testify for the solicitors, but I do want to kind of outline the general environment that we all work in. I mean, the solicitors have to make, they've got, X amount of resources. They have to make some difficult decisions. They may have, for example, class action suits that may affect thousands of workers. They may have a very difficult penalty case, settlement case for a worker fatality that they have to deal with. And then they also may have whistleblower cases that may only affect one worker for a few $1,000s. I'm not saying that these aren't important, certainly to that worker who is unfairly fired for exercising his health and safety rights, but the fact is that there are some difficult decisions that have to be made here. But again, let me reiterate that those difficult decisions are forced upon them because we're working in this dysfunctional system, and that's what we need to change. We need to change the system.
Well, let me say that I also feel that we need to strengthen the system. We should really be protecting workers. Even worse, back about 10 or 15 years ago, there was a move afoot by the then-controlled Republican Congress to have OSHA have inspections done, and that the company would pay for the inspections, and that the results would be given to the company without public knowing what was in it, and therefore the company then would supposedly use this as a working tool to go and try to correct problems that the OSHA inspectors found. Of course, it fortunately really did not get off the ground, because it's difficult enough under the environment that we currently have for the workers to get justice. If you have the company paying for the inspection, it would be total injustice, in my opinion. So with that, thank you, and I'll yield back the balance of my time.
We are going to have a second round of questions, and I will yield to Congresswoman McMorris-Rodgers.
Thank you, Madam Chairwoman. Much of the work of this subcommittee focuses on how we can get employers and employers to work more proactively to prevent accidents and illnesses from occurring and encourage that participation. And Mr. Morikawa mentioned the results of your electrical contractors transmission and distribution strategic partnership for safety and the success of it. I wanted to ask you how you believe we could translate that experience into OSHA's everyday practices, especially as the agency has announced cuts in this area.
Thank you very much for that question. The work with the ET&D partnership has been particularly positive and reinforcing because you took parties who were traditional adversaries and competitors, and you pulled them all together for a common purpose. And that common purpose was to reduce injuries and fatalities on the job. So it starts with that philosophy. It's an attitude. It's a desire to make a cultural change in an industry, which is very significant, as you can see. When you get everybody together on a cooperative basis, join hands to try to reduce injuries and fatalities and to find the causes and to stop them, you can have dramatic effect. Now, the issue I'm concerned with is the fact that, first of all, I don't take issue with the fact that OSHA needs to have a strong and vibrant enforcement program. Neither the Chamber nor I personally have ever taken the view that an enforcement program should be replaced by cooperative programs. What I think should be done, however, is that groups of employers or individual employers that have indicated a commitment to prevention of accidents and fatalities on the job should be encouraged by OSHA. They should be incented to do the right thing. Now, commonly there is the notion that companies that go into partnerships are supposed to gain some sort of strategic advantage, that they're looking for some type of immunity or they're looking for some kind of special treatment from OSHA. ET&D is an excellent example of that. These issues came up at the time we formed ET&D. The question was asked by OSHA, what sorts of immunity, what special treatment would you like as a result of that? Is that what you're really after here? And resoundingly, the members of the partnership, again, remember this, union, non-union companies, together with one of the largest labor unions in America, along with these trade associations, got together and said, no, we're not looking for any special treatment. In fact, we're not looking for inspection immunity, citation immunity. We're not looking for special points and privilege, et cetera. We're looking for your cooperation so that we can get together as a group and solve these problems as a group and not do it by fighting with each other. Yes. Again, the partnership never took the position that they shouldn't be cited if they violated OSHA standards. But what we did do is we focused on compliance cooperatively, and you can see the dramatic impact that's had. And OSHA should be encouraged to do that.
Thank you.
Just for the record, we fully support that partnership. We love that partnership. We think it's been very effective, and we have not cut back funding for these partnerships.
Okay, great, thank you. And Madam Chairwoman, I have a case I'd like to submit for the record. This is on April 19th, 2010, the National Labor Relations Board found that the International Union of Operating Engineers, Local 513, in violation of the National Labor Relations Act for finding a union member for reporting another union member's safety violation to their employer. IUOE had fined an employee $2,500 for informing his employer that a fellow employee and union member had violated a safety protocol. And I'd like to submit that for the record. And
without objection.
And I'd like to ask Ms. Reinhardt if the AFL is examining any changes to protect whistleblowers within the union.
Thanks for the question. I'm not familiar with the case that you just mentioned, but I'll take a look at it. The stronger whistleblower protections in PAWA would apply to unions as employers just as they apply to private sector employers, and we fully support that.
Okay, and I yield back.
Thank you. Now, turn on the light. Otherwise, we go on and on. I was quite surprised that Mr. Chin can sit here this morning and ask what motivates updating PAWA? Why bringing Section 11C into the 21st century, 11C of the OSHA Act, is what motivates us to do that after hearing the Secretary and hearing the witnesses before you and knowing the stories of the family members sitting behind you. That just, I find that very hard to believe. So then the idea that from that statement to during times of bad economic situations around the country, 10% unemployment, that we can't upgrade and fix what's so necessary to our workers and for our workers. So I'd like to ask the members of the witnesses if they think there's a time and place when it's we can't afford to take care of our workers and we can't afford to update their work sites and our laws that protect them. Starting with you, Ms. Reinhardt.
May I speak for a second?
Oh, sure, Mr. Jorgensen.
2 points here. First of all, OSHA should be a police officer. And, you know, just for the record, I am on the minority side of the House when it comes to my political group.
Oh, gosh, then we're not going to listen to you.
So,
go ahead.
I think, you know, if a person comes forward and says something and he gets beat up for it, he's going to tell all of his friends and nobody else is going to come forward.
Yes.
Bottom line, like I said.
All right, thank you for that.
I took my, you know, when I was talked about coming here, I went to my employer, my current employer, which is Sunoco out of South Carolina. I explained what had happened to me, what I knew of what the law was for, and said, should I go? Because, you know, and mentioned, you know, I know it'll be a good experience. And my manager said, you should go, not just because it's a good experience, because it's right.
Oh, thank you to that manager. Thank you for sharing that, Mr. Jorgensen. Ms. Reinhardt.
Thank you. Just a couple of comments. One is there's a desperate need to update and strengthen this law, and I just want to reinforce a point that's sort of come out in the course of this discussion, but that really needs to be made clear, and that is what an outlier the whistleblower protections in the OSHA Act are relative to really virtually any other law, and the absence of a private right of action and ability of workers like Mr. Jorgensen to bring their case forward if the Secretary of Labor can't act. The OSHA Act is way out of the mainstream, and it's past time to bring it into the mainstream of other whistleblower laws. So thank you for your efforts to that end.
Okay, you're welcome. Dr. Mort.
As a professor of public health and someone who studies history, I mean, we've heard through the time of the OSHA law that there's, you know, you never have a perfect time to reduce injuries and illnesses. If you listen to the business community and you look at the difficult time that OSHA has had in regulating many, many hazards, you know, we would never get anything done if people were looking for the perfect time. And I also would like to draw people's attention to the hearing yesterday in the Senate, which focused also on worker health and safety, and it came through loud and clear that during the most difficult times when our economy is in the tank, that's the exact time that workers are most at risk of being exploited. And that's when we need very strong whistleblower protection laws. And people will take risks if they're afraid of losing their job or they're laid off, and that's why we really need these strong whistleblower protections.
Thank you, Mr. Morikawa. I'm going to take the prerogative of the chair and let Ms. Ford and Jordan speak. Also. Would you like to respond to this?
Yes. Well, first of all, I think that PAWA is an act which has significant merit. There's no question that there are issues that have been raised that have led everybody here to this meeting today. I think what we're discussing really are aspects of PAWA which we think just don't necessarily work in real practice. And what we've tried to inject into the discussion today is a real-life experience that places us in a somewhat unique position of actually agreeing with each other. I'm actually talking to Mr. Barab, who I've known for many years, and we've had differences in the past, but we certainly have no disagreement here about the impact that certain aspects of this legislation can have in terms of taking an agency which is really faced with a difficult mission of trying to enforce laws for so many millions of workplaces in America with a very, very small staff. And as a consequence of that, they are faced with the challenge of trying to decide which cases to pursue, how to pursue them, and when to pursue them. The issues of timing, resource deployment, et cetera. And in that respect, we certainly respect and we give deference to the prosecutorial discretion that agencies such as OSHA and the Solicitor's Office need to have in order to enforce the laws that they've been charged to enforce. So in that respect, they really are acting and should be acting as the representatives of employees in these types of cases.
Okay, thank you. Ms. Ford.
Like Dr. Munforton said, I would have to agree. There is probably no time, the best time to fix and make safety. However, in saying that, I hope the employers know that it was the hard work of people like my uncle and my father who make these companies what they are today. They have the name, but it's the people that make it. And if it was not for them, they wouldn't be where they are.
Thank you very much. Secretary Barab.
Thank you. I've been working in this field for close to 30 years, and one thing that's more and more obvious to me is that OSHA doesn't work and workplace health and safety doesn't work unless workers are actively involved. And the only way workers are going to be actively involved if they do not fear retaliation, and that's not the situation now. Now, I just want to mention one thing. It is true that OSHA only finds merit in 25% of these cases. That does not mean, however, and I certainly don't agree with the fact that OSHA thinks that the other 76% of these cases are frivolous. All this means is that these workers, nor does it mean that these workers didn't actually have a good faith belief that there was a health and safety problem or that there was a health and safety problem. It simply means that under the way the law is written now, they could not assemble the kind of evidence they needed to prevail in the case. So again, I totally reject that figure means that these cases were frivolous. And second, just in terms of responding to Mr. Morikawa, I do understand that, obviously we all understand that there are serious resource problems, and I will take your comments as an endorsement for increasing our resources. But I also want to say that just for that reason is why we need protecting America's workers' rights, why we need a private right of action and the other elements that are in the whistleblower provisions of this law. So it's been 40 years now since this law was passed. There are some very clear, very obvious problems that are keeping workplaces from being as safe as they can be, and now it's high time to actually make those changes.
Okay, it appears I'm really out of time. Ms. Shea Porter.
Thank you. I just have a quick question. But first I wanted to say that I do know that most companies are very interested in keeping their workers safe, and I think that, they do everything they can. I did work in factories through college, and I saw some pretty awful things, and I saw some pretty wonderful employers, and I think that really reflects, what the world is like. And that's why we have to have a strong agency for the few who would not follow the rules. But mostly I think that we've come a long way since I was in college, and I'm happy to see that. I do go to factories, and I look very closely at so many markers that maybe other people would know to look for, and I appreciate that I have seen a tremendous improvement. Having said that, Ms. Reinhardt, I felt I needed to give you an opportunity to respond to Mr. Chin's comments at the end of my last 5 minutes, because I agree with Mr. Barab about what those numbers really signify, but I wanted to give you a chance to talk about whether they are frivolous suits and exactly what's happening out there, in your opinion.
Thank you. Really, very little is known about the reasons why the cases were dismissed by OSHA, withdrawn by the complainant, not processed further through the system. In a good number of cases, I imagine the worker missed the statute of limitations, which is a problem that's addressed by the pending legislation to lengthen the exceedingly short statute of limitations that currently exists in the OSHA Act. If a worker was fired for filing an OSHA complaint and filed their whistleblower complaint on day 35 as opposed to day 30, that case would have been dismissed. It wouldn't have merit under the current law, but it doesn't mean that the worker wasn't wrongfully terminated. They just missed the statute of limitations. So that's just one example. There's a lot of things that go into whether or not a case is withdrawn, dismissed, or doesn't proceed further through the system. So I think that you can't just assume that they all didn't proceed because they were not meritorious or they were frivolous. There's just no evidence to support that. And as I said earlier on this point, workers don't bring these cases forward lightly. They know the consequences of coming forward and filing a claim with the government against their employer and what that could mean for them in their job, in future jobs, and so forth. They don't bring these claims forward lightly, which is all the more reason why we need a stronger law to protect them when they do come forward to raise these concerns. Thank you.
Thank you. And also I would add that sometimes has an impact on them in their community, in their social life, because of the role, if it's a very prominent role that the business has in a community. So I would agree with you. For the most part, they don't step forward lightly. It's a serious issue. Thank you, and I yield back.
No. Well, in closing, I'd like to thank this wonderful panel of witnesses. Every one of you participated absolutely to the degree that we were hoping. We've learned from you, and we will make your testimony will make a difference. And thank you, families, again, for being here, and loved ones and friends of those who have died at the workplace. Today, as we said, is Workers' Memorial Day, a day when we honor fallen workers and recommit ourselves to ensuring the safety and health of all workers. As our witnesses have testified, it's been 40 years since the OSHA Act was amended, and, well, passed in the first place and fully amended. And in those 40 years, we've learned a lot about working and what needs to be changed. And PAWA will modernize the OSHA Act, give workers and their families the protections they need to report unsafe and unhealthy practices, and be involved in the process when an incident causes a fatality or a serious injury. I'm looking forward to our bill, PAWA, proceeding through the committee and the floor for a vote, and it wouldn't have been possible without your input and without your interest, and I thank you all very much for that, and thank you for coming. As previously ordered, members will have 14 days to submit additional materials for the hearing records. Any member who wishes to submit follow-up questions in writing to the witnesses should coordinate with the majority staff within 14 days. And then I ask unanimous to consent to include the following 14 items into the hearing. So without objection, I would like to place the following letters into the record. 1, the discussion draft for Protecting America Workers Act of March 9th, 2010. 2, data on the Solicitor of Labor's disposition of 11C retaliation cases from 1995 through 2009. 3, statistics and outcomes on whistleblower cases filed with OSHA for 2008. 4, OSHA's actions on 11C case completed in fiscal year 2009. 5, DOL's letter to Neil Jorgensen dated April 7th, 2005. 6, the ADM Milling Company informal settlement agreement. 7, an email from OSHA to Ms. Ford. 8, the Kansas Supreme Court case Flanker versus Willamette Industries, Inc. 9, the Missouri Court of Appeals case Shawcross versus Pyro Products, Inc. 10, the U.S. Court of Appeals case Wood versus Department of Labor. 11, an Administrative Law Journal article by Eugene Fidel titled Federal Protection of Private Sector Health and Safety Whistleblowers. 12, an Employee Rights and Employment Policy Journal by Jared Gonzalez title, A Pot of Gold at the End of the Rainbow, an Economic Incentives-Based Approach to OSHA Whistleblowing. 13, a GAO report titled Better Data and Improved Oversight would help ensure program quality and consistency. And finally, 14, comparison of anti-retaliation provisions in the other laws prepared by AFL-CIO, National Labor Relations Board case dated April 19th, 2010. With that, this hearing is adjourned. Thank you very much again.